I think we're live. Good after, or I guess good morning, everybody. My name is Eric Tonsul. I'm one of the shareholders in the POA department at Roberts Markel, Weimer Butler Haley. Thank you for joining us today. We're going to be talking about neighbor-to-neighbor disputes and when the association should get involved, when it may not want to get involved, things of that nature. So we're going to dive into that a little bit later. But before we get into that, I want to let everybody know that the information presented today is based on the laws that exist as of today, November the 9th, 2021. The information presented is for educational purposes and does not constitute legal advice. If you need legal advice relating to any of the topics discussed, please consult your attorney. So what we're going to be, as I said, we're going to be talking about neighbor-to-neighbor disputes. I anticipate this webinar going, it's not going to be that long, actually. It's probably about 25 minutes. However, you can submit questions in the Q&A portion of or section of the Zoom platform. So if you do have any questions, please type them into the Q&A. And after I conclude with the presentation, I'll go through the questions and answer as many as I can, and we'll go from there. So without any further ado, neighbor-neighbor disputes are common, as we all know. And, dealing with property owners associations, it's almost inevitable that you're going to run into, two neighbors having a dispute amongst themselves. And more often than not, the neighbors resolve the dispute, between them without ever involving the association. However, depending on certain circumstances and scenarios, the association may need to step in. So we'll talk about if and when an association should consider stepping in a neighbor-to-neighbor dispute. So some common issues that you'll see on the screen here, as far as what may constitute or give rise to a dispute between neighbors, or fireworks, barking dogs, parking issues, children in the street, all those kinds of things. So again, I'm sure you guys, if you're watching this webinar, you've dealt with some of these on occasion. So with respect to enforcement of the association's declaration or restrictions, under most restrictions, most sets of declarations, the owners as well have just as much standing as the association to enforce the restrictive covenants in the declaration. There's some sample language on the screen that you'll see. I'll read it very quickly. That the terms, covenants, conditions, restrictions set out in this declaration shall run with the land and bind the development, and shall inure to the benefit and be enforceable by the association and every owner, including the declarant and their respective legal representatives, heirs, successors, and assigns. So what that means in English is that the owners, again, have just as much standing as the association to enforce the restrictions, including filing a lawsuit against their neighbor for a deed restriction violation. Again, I say deed restriction violation because that section does not, or that provision, I should say, does not give an owner the right to pursue an owner to enforce the association's lien rights or levy fines, that kind of thing. So in other words, an owner cannot try to, if their neighbor hasn't paid assessments to the association, the owner does not have the right to pursue that owner for failing to pay assessments to the association. Again, because again, those assessments deal with the association's lien rights. But again, with regard to the use restrictions or architectural restrictions, that kind of thing, an owner does have standing to bring an action against a neighbor for a violation of the declaration. Next slide, please, Lindsay. So when should the association get involved? And I have multiple slides on this. So we'll be getting more further in depth about this particular issue. But the main issue, or the main point of consideration, is the extent of the issue or the dispute. For example, does the dispute involve the threatening the health and safety of others? And could it result in a potential reduction in property values, or is it a disturbance that affects multiple neighbors? It's not just John Smith versus Jane Doe. It's John Smith versus his whole street. So those are some things that to keep in mind with regard to when an association should consider getting involved. Again, we'll talk about this more in depth in the next upcoming slides. So the first thing to do when you have a neighbor-to-neighbor dispute that is brought to the association's attention is to check your restrictions, see whether or not the association may actually have an obligation to step in and get involved in the dispute between the neighbors, or is there discretionary enforcement authority in the in the declaration, meaning the association does not have an obligation, but it has a discretion to determine whether or not it is or is not going to get involved in the dispute with the owners. Is it a potential or possible violation of the restrictive covenants? If it is a violation of the covenants, then the association again has the obligation to enforce its restrictions. So if the dispute involves a violation of the covenants, then the association may definitely consider getting involved. The failure to act may create liability for the association. I'll go much more in depth on that in the upcoming slides. And that relates to, for example, FHA liability, but again, the Fair Housing Act. So we'll talk about that a little bit later. And other considerations that a board should consider when determining whether or not to get involved is it the best use of the community time and funds, and whether or not there's community support or disapproval. And so those are some issues to consider when you're looking at whether or not an association should get involved in these types of disputes. For example, the best use of community funds and time, if it's something that's really minor between two neighbors and the association gets involved and ends up in a lawsuit, that kind of thing, the other owners in the community may be wondering, why in the world are we spending our assessment dollars on this issue that's really just an issue between these two neighbors? Why are we doing this? So again, those are an example of when are factors to consider before getting involved in a dispute. Next slide, please, Lindsay. Okay, so in the previous slide, I had mentioned that there could be potential liability to the association for not getting involved. And so the Fair Housing Act prohibits different kinds of housing discrimination concerning a person's race, color, sex, national origin, familial status, religion, and disability. However, there were changes to the law in 2016 that subjected associations to potential liability for its own conduct in dealing with protected classes that I just referenced, and failing to act in the face of discrimination. So you may be kind of scratching your head saying, well, give us an example, Eric. I'm happy to do so. So, for example, let's say we had two neighbors that were they just Hatfields and McCoys. They don't like each other. And one of the families is African-American, the other one is not. And the non-African-American family puts up a Confederate flag in their front yard just for the sole purpose, really, of just antagonizing their neighbor. If the neighbor contacts the association about this, and the association has an enforcement right or has an enforcement mechanism to pursue that owner for unauthorized flag. For example, there are many restrictions and declarations that prohibit flags except for, in the U.S. flag, Texas flag, and the armed forces flags, but it doesn't allow any other types of flags. So in that situation, if this association had that restriction where only those three flags could be displayed and nothing else, and this owner puts up this Confederate flag and notifies the association does not take action, the association could actually potentially be, in violation of the FHA because it's promoting the discrimination against one of its owners. So that's an example of, how by not acting or taking action or getting involved, the association could inevitably subject itself to liability for failing to get involved. So something to keep in mind, something that if you ever have that type of situation, definitely contact your legal counsel to get legal advice as to the association's options as to what it should or shouldn't do and for that type of situation. Next slide, please, Lindsay. So again, in order to get more familiar with what an association's obligations, board members are encouraged to, educate themselves on the requirements under the FHA. Obviously, review your governing documents and determine the ability to prevent discrimination. And you may even have to revise your documents in order to address these types of issues. But again, as I mentioned in the previous slide, definitely seek legal counsel to get advice as to what is the best method or course of action the association should take in order to address these types of issues. Next slide, please, Lindsay. So in declarations, you typically have a catch-all clause, which is often the nuisance annoyance provision. And we call it a catch-all because there's just no way that when a declaration is drafted, it's going to include every kind of violation that could ever be possible. It's not feasible. And if somebody tried to do it, you'd have declaration that would be about 1,000 pages long, and it probably still wouldn't include all the potential violations that could arise in your community. So the nuisance annoyance provision is a catch-all provision, which basically says, it may not specifically say whatever the owner's doing is in violation, but we could say it's a nuisance annoyance to the owners or to the community, depending upon the language in the declaration. And also the nuisance annoyance can be used in conjunction with other restrictions. So for example, you have a declaration that says that you have to maintain your lawn in a neat and attractive manner on a regular basis. And an owner fails to mow their grass regularly and they have 2 foot tall grass in their front yard, you could pursue them for not only the violation of the lawn maintenance restriction, you could also include that the violation is a nuisance and annoyance to the community. So on the screen, you'll see some sample language that you'll often see in declarations, and this is very boilerplate. I see this quite frequently. No noxious or offensive activity shall be undertaken on any lot, and nothing shall be done which is or may become an annoyance or nuisance to the neighborhood or surrounding lots. So that is the nuisance annoyance catch-all provision. Now we'll say this: if that is your only provision that you have for a particular violation, it's not the strongest argument. It's an argument for sure, but a lot of judges have a hard time, with the whole all-encompassing catch-all provision. So if that's the only thing you've got, you might want to look into beefing up your restrictions or adopting guidelines, that kind of thing, to maybe illustrate or articulate, what constitutes a nuisance annoyance, to give you some more strength as to enforcement of that particular provision. Next slide, please, Lindsay. So for annoyance and nuisance, subjectivity is often a concern. As I mentioned, to avoid this issue, guidelines are recommended. But to give you one of my old war stories, this happened, maybe 15 years ago now, where I issued a neighbor-to-neighbor dispute where a neighbor was complaining about something in his neighbor's backyard, which it was his backyard bordered his neighbor's backyard, obviously. And so when this guy would go to the second floor and the restroom on the second floor, stand on the toilet and look out the window, he could see something in his neighbor's yard that he didn't like, and that was a violation of the restrictions, allegedly. So I wish I was making that up, but I'm not. That actually happened. And so that is a personification, the epitome of a neighbor-to-neighbor dispute. I mean, without that guy doing what he was doing, there's no way he would have seen that. And of course, there was backstory. The neighbors didn't like each other, and so this guy was trying to, get his neighbor in trouble and cause or just make life difficult for the backyard neighbor. But again, subjectivity is the concern. It is the complaining owner of a neighbor-to-neighbor dispute being reasonable, being objective, or is this something that is really, it's just, you got a Hatfields and McCoy situation and they're just being petty for the sake of being petty. If it's petty for the sake of being petty, that's usually something where the association does not want to get involved in. Again, it all depends on a case-by-case basis of the facts that are pertinent and germane to the dispute between the neighbors. So when an association does get a complaint from a neighbor about another neighbor, the association should do its due diligence, do some investigation, and determine whether the complaint has merit, or is it baseless, or is it just really out there. Like my toilet example, that's one that's really out there, and say, Mr. Smith, you have just as much standing as the association to enforce a restriction. So if you feel the need to, pursue your owner, good luck, that kind of thing. But if it's something where a front yard is a mess and the neighbor and the owner of the front yard is a real jerk and everybody on the street is complaining to the association about this guy's yard and everything else, well, that's different. That's something where the association should definitely consider getting involved, because not only does it involve multiple neighbors, but it also is about, in this hypothetical, it's a violation of the restrictions. And so, and also there's sometimes where, the issue should be left to the owners to handle between themselves, or the city or the county may need to get involved depending on what the issue is. Next slide, please, Lindsay. All right, excuse me one second. All right, so the use of fines can be employed when there is a violation of the restrictions. But again, the association has to have fine finding authority within its governing documents, either the declaration or the bylaws. It's not automatic, although condos do have automatic finding authority pursuant to 82-102 A12. But for single family and townhome associations that are governed by 209 of the property code, that authority is not automatic. You cannot just levy fines. You have to have authority to levy fines in the declaration or the bylaws. And also the fines are not, if you do have that finding authority in your governing documents, those fines are not automatically secured by the association's assessment lien. The declaration has to specifically say that the fines are secured by the association's assessment lien. If you just have finding authority in the bylaws, those are more than likely going to be unsecured fines, meaning they are not secured by the association's assessment lien. So again, you know, look at your governing documents and see what they say as far as the ability to levy fines, the authority and ability to levy fines, and whether or not they're secured or unsecured. Fines should be used as leverage, not profit. The board should not be looking at fines as a money generate or profit revenue generating mechanism. You know, we're trying to get compliance. That's, at the end of the day, that's what we're trying to do. We're not trying to punish people. We're not trying to be punitive with fines. We're just trying to use them as leverage to get owners to bring their property in compliance with the restrictive covenants. Fines must be reasonable. And, you know, they're for both condos and 209 associations. There are conditions precedent that must, notice requirements that must be sent to owners prior to a fine being levied. You can't just, you know, so-and-so is doing, you know, isn't cutting their grass. Okay, $20 fine. You've got to follow the process, which is in 209-06 of the property code and 82-102D of the property code that applies to condominiums. Next slide, please. So something the association also might want to consider as far as when there is a neighbor-to-neighbor dispute is alternative dispute resolution, such as mediation. Mediation could be an option, and hopefully it'd be something that the association just suggests to the owners that are having the quarrel amongst themselves, and not have the association get involved. With the mediation or ADR, which is alternative dispute resolution, you can save some time, save some money. You avoid litigation and high attorney's fees. You know, hopefully it results in a quicker resolution than if a lawsuit was to be filed. You have an independent, impartial individual making the judgment as far as the dispute. And, you know, you could, if there is a mediation and there is a settlement at the mediation, you could have a confidential settlement so that to maintain confidentiality to avoid things getting out. So again, just something to consider. Admittedly, this isn't often used. ADRs is not usually the go-to mechanism as far as or procedure when there's a neighbor-to-neighbor dispute, but I'm just mentioning this so that you guys are aware that it does exist and there is a potential to be used in some situations. Next slide, please, Lindsay. So when should a board contact its attorney when there is a neighbor-to-neighbor dispute? If the parties refuse to cooperate, that's a good start. You know, they're being extremely difficult, and there's one says the sky's blue, the other says the sky's red. Maybe a situation where the association does need to get involved. Again, contact your attorney. The dispute involves a violation of the covenants. Again, like I said, the association may have a duty to get involved and intervene when there's a violation of the covenants. So that's another situation where counsel should be contacted. If the association is unsure of its duty to enforce, you know, you read your restrictions and you're not quite sure whether or not you have an obligation or, you know, a duty to enforce, or it's discretionary authority. That's one of the situations where you can't consult get with your lawyer and find out what he or she has to say as far as the association's obligation as far as that goes. If the dispute affects others in the community other than the parties at issue, so as I mentioned earlier, the example I gave was individual lets their yard grow 2 feet tall and affects everybody on the streets upset with this guy because everybody else is spending the time, money, and effort to keep their property looking nice, but this one joker is not playing ball with the rest of the team. This might be a situation where, although that is definition of neighbor-to-neighbor dispute, the association should probably get involved in that situation. If the issue involves complex property law, like if there's a boundary dispute between two owners, something along those lines. Again, something that an attorney should be consulted about as far as the association's enforcement options. And lastly, the FHA issues that I had mentioned earlier, the Confederate flag example. Consult your attorney to see, do we have an obligation to step in at this point in order to avoid any potential FHA violation allegations against the association. Next slide, please, Lindsay. So on the attorney's fees, pursuant to 5.06 of the property code, the party who brings the action and prevails in the action is entitled to recovery of attorney's fees. So what does that mean? If the association sues John Smith for his yard and we prevail in the lawsuit, get a judgment, we are entitled to seek the recovery of our attorney's fees in the judgment pursuant to 5.06 of the property code. If we file the lawsuit against Mr. Smith for his yard and Mr. Smith prevails in the lawsuit, he is not entitled to seek the recovery of his attorney's fees from us. And the reason being is, as you'll see there in Section A of the statute, it's the party that brings the action and prevails in the lawsuit, or asserted the action and prevails in the lawsuit. In my hypothetical, we sued Mr. Smith for his yard. He did not sue us, so he was not asserting any action against the association. So that in that circumstance, because we brought the action and we prevailed and got a judgment, we are entitled to the recovery of our attorney's fees. Now, if Mr. Smith had filed a counterclaim of some sort against the association, maybe a declaratory judgment action, which we call a DEC action, that may entitle Mr. Smith to recovery of his attorney's fees if he prevails. But again, with regard to 5.06, it's the party that brings the action and prevails is entitled to seek the recovery of their attorney's fees. Now, again, that's not a guarantee that you're going to get 100% of your attorney's fees awarded. It's up to the judge or jury to determine how much of those attorney's fees they're going to award the association. And the amount of the attorney's fees is the court will consider those 1 through 4 that you see on your screen, the time and labor required, the novelty and difficulty of the questions, the expertise, reputation, and ability of the attorney, and any other factor that the judge or jury deems appropriate or reasonable. And so the term prevailing party in the statute means both the association and owner. So as I mentioned at the beginning of this presentation, an owner has just as much standing as the association to bring an action against another owner for a violation of the restrictions. So in this case, Mr. Smith's yard, let's say the association for whatever reason doesn't get involved, but Mr. Jones doesn't like the yard and he brings a lawsuit against Mr. Smith for his overgrown yard. At that point, if Mr. Jones prevails in the lawsuit that he filed against Mr. Smith for his yard, he is entitled to seek the recovery of his attorney's fees from Mr. Smith. All right, next slide. I think there's a conclusion slide, if I'm not mistaken. It is. So in some, neighbor-neighbor disputes are frequent. Communities and associations will always be struggling with the issue whether or not to become involved. And I know you guys hate to hear this, but this really is an it depends answer. It's a case-by-case basis as far as when there is a neighbor-neighbor dispute, whether or not the association should get involved. Again, hopefully this webinar, you guys have gotten an idea of the types of situations where the association should definitely consider getting involved, in the type of situations where it truly is the epitome of a neighbor-neighbor dispute, and the association really shouldn't stick its nose into that battle. And so if the association must intervene, there's fines, mediation, covenant enforcement, and attorney assistance may be available to resolve the issue, and definitely seek legal counsel to protect the decision not to act. Again, you don't want to say we're not going to get involved and come to find out by not getting involved, you guys are, an association is subjecting itself to an FHA violation or something along those lines. So when in doubt, if there's any questions, definitely contact your legal counsel to find out what the association's options are. And that is it for the presentation. I'm going to go to the Q&A. I've got a couple of Q&A questions here. Let's see here. Though the explosives violate homeowner association deed restrictions, HOA leadership feels powerless. Let me read that again. Though the explosives violate homeowner association deed restrictions, HOA leadership feels powerless. I assume you're referring to fireworks. I'm not quite sure, but I think that's what you're asking. And yeah, that a no, I'm just going to go, I'm going to act like that's what you're asking, Mr. Young. The enforcement of a no fireworks provision is extremely difficult because fireworks are often done middle of the night, on holidays. Nobody's driving around trying to, see who's popping fireworks. And not only that, a lot of kids go to their friend's house to pop fireworks, and so they may not even be subject to the restrictions because they're not an owner. So it's a very difficult provision or restriction to enforce. It is what it is. And so there's a lot of boards that have that very same mentality that, yeah, we've got it, we try to enforce it, but it's just extremely difficult to do. And it is extremely difficult to do. So, but again, you do your best, but when it comes to fireworks, it's extremely difficult. But again, neighbors, if a neighbor knows their neighbors are doing it, they have the standing to pursue that owner for violating the restriction, assuming they have a no fireworks provision. All right, next question. What about Black Lives Matter flags, LGBT flags, come and take it flags? Could those be construed as freedom of speech? The big question are Trump flags. Would those be political signs? I would. So this was a hot button topic, especially last year, where you have like the Black Lives Matter flags and the Trump flags were really the two hot button issues last year. And, in my opinion, a flag is not necessarily a sign. If, for example, if somebody had that Trump flag that said no more BS, Trump 2021 or whatever it said, the commentary on the flag could be interpreted as a sign, because it's more of a sign than a true flag. So I would not consider that a political sign. And also because of the no more BS provision that could be offensive to individuals. So things like that could be regulated. The Black Lives Matter sign or flags, LGBT, those are a little bit more touchy. Admittedly, and a lot of associations left those flags up because of the culture of the nation at that time, and didn't want to incite. The African American population had a very deep rooted cause, and there wasn't a desire to trying to let people live their lives and be all right with it. So there was a leniency on the enforcement of those types of issues. But again, if there's a no flag sign or no flags restriction in the declaration, an owner, if they didn't like it, they could pursue it. They have that right. But as a result of associations, again, case by case basis, want to make sure we're not, stepping into something that's going to create a media frenzy for your association, which, those Trump flags and the BLM flags definitely had that potential. If you are protected by another law, can you still be sent notice for a violation? For example, homeschooling. Okay. Well, it depends on, homeschooling is permitted, but, again, if you have restrictions that relate to, commercial use of your property, oftentimes the restrictions will have something that relates to, doesn't increase in traffic in the neighborhood, and, don't have employees coming and going. You're not storing materials at your property. So if it's a situation where the business, in this case, for this question, the business use of a property is not creating a detrimental effect to the neighbors, then it should be acceptable. Again, it all depends on what your restrictions say. So I'm giving just very general commentary on this. I'm not giving specific legal advice. So that's something, if you have an issue, consult your attorney to get more information on that. Next question. Would you recommend the HOA get involved with a shared fence issue between neighbors? More than likely not, unless the shared fence issue was somehow a violation of the restrictions. But if it's like there's a shared fence and it's kind of dilapidated and deteriorating, and one owner wants to fix it, the other doesn't want to pay for it, and there's no restrictive covenant violation there. Let's say it's a backyard fence, so you can't see it. It's not within public view. That's a situation like that. I would probably recommend to my client not to get involved in that situation. All right, next one. I saw something about condos and water between units in the first list. Please address this. So if there's a leak if there's a leak between condo units and there's no and there are no there's no damage to the common elements. Let's just assume that it was a leak. It didn't create any damage to common elements. So no common elements were damaged as a result of the leak. So the association's insurance would not kick in pursuant to 82-111 of the property code. So now you just have a dispute between owners. Let's say the upstairs unit owner doesn't want to pay for the downstairs unit owner's, damage. So in that situation, you have a neighbor dispute as to what to do. And again, depending upon if the leak had caused damage to the common elements, the association has an obligation to get involved. And whether or not the insurance, if the association has an insurance deductible resolution, then that may be triggered as far as the damage to the common elements does not rise to the level of the deductible, and therefore the insurance deductible resolution kicks in and says who's responsible for what. But again, if there's no damage to the common elements and it's just damage to one unit and it's caused by another unit owner, then that unit owner, that's a neighbor to neighbor dispute, which the association would most likely not get involved in. Again, this is very general advice on a hypothetical. So if you do have a situation like that, get with your attorney and find out exactly what the association's options are. If the association has sent notices in the case of excessive barking and animal waste, as well as contacting animal control and the local police department, have we completed our obligations or should more be done, including a lawsuit? On the excessive barking, in that situation, I would, if that came to me from a client, I would want to find out, is it just one owner that's complaining about it, or is it several owners that are complaining about it? If it's several owners, then more than likely the association would get involved, being a nuisance and annoyance to the community, as well as the animal waste portion of this. The police is probably not going to do much with something along those lines. But again, if it's just one owner that's complaining about this dog and nobody else is complaining, the adjacent neighbors are not complaining about it, that's probably going to be just a neighbor dispute, and let them resolve it themselves. Meaning the owner that's complaining, again, has just as much standing to bring an action against the neighbor for the barking dog under the nuisance annoyance provision, assuming the restrictions have a nuisance annoyance provision. What are some resources available to homeowners if the association is not backed by the governing documents to be able to mediate? Well, again, mediation does not have to be in the governing documents in order to use alternative dispute resolution. And for example, I live in Harris County. We have the Harris County Dispute Resolution Center. It's a free mediation service. I'm sure that there's actually, I'm about 99.9% sure that other major cities have the same type of free mediation services, such as the DRC here in Houston. Now, we'll say this, unfortunately, you kind of get what you pay for. But again, that is another resource. And again, to be clear, you don't have to have ADR, alternative dispute resolution, which mediation is a form of ADR. That does not have to be in the declaration in order to take advantage of it. All right, next question. Resident has harassed many owners. Many police reports have been filed. He was quiet for about 5 months. Now he's beginning again to harass owners. New owner is asking about this individual. Should the HOA tell the new owner the history of the individual causing the problem? Yeah, I mean, it's a situation where, if the new owner is asking, then it's okay to advise the owner. I would not just voluntarily provide that information to the new owner. Again, try not to get involved, as much as possible. But if a new owner does come to the association, say, hey, what's going on with this Mr. Smith guy? He seems to be a real jerk, and goes into it. At that point, once that door's been open, then I would say, yes, you can provide that information. But until that happens, I would not just volunteer basically bad mouthing owners in the community. If there's a drainage issue, should the HOA get involved? In the past, I've told them to reach out to the city. again, this is a difficult question to ask because there's so many moving parts, and this is, two sentences. This is one of the issues where you'd really have to, I'd have to know the facts, and I'd have to know what the restrictions say in order to provide you with a reasonable answer. But what I will say is that there are, the water code prevents an owner from diverting runoff waters to a neighbor's property. And so if an owner has built something on their property that is diverting the runoff from like rains and stuff on the neighbor's property, the other neighbor could potentially pursue that owner for a violation of the water code. Now you got to be careful with that because you don't want to provide legal advice to an owner. You say, hey, you have a potential violation of the water code because you can't divert surface waters to their property. That's you're basically giving legal advice. So what I would suggest is if you have something, if that's what your question was referring to, just say, hey, like, we, unless there's something in the restrictions that gives the association the authority to intervene, say, hey, like, you might want to consult legal counsel. You may have, recourse per Texas statute or something along those lines. But again, don't give legal advice unless you're a lawyer. Our barking dogs a neighbor to neighbor issue. I kind of already addressed that a little bit earlier. If the barking dog addresses there's complaints from numerous or multiple owners, then it definitely could escalate into an association issue. If it's just one-on-one, probably not. When is the association responsible for water damage repair between units in a condo? Again, it depends on what your governing documents say. Without having the governing documents, I can't say one way or the other. Again, you're definitely responsible for damages to the common elements. Now, you may be able to seek recourse from one of the owners that caused the damage. Typically, the declaration of the bylaws will have a provision that states that any damage to common elements caused by an owner's intentional or negligent acts, the owner is responsible for reimbursing the association for the cost of damage to the common elements. But again, it's a case-by-case basis depending on the facts. So I can't just say, here's where the association is responsible for the water damage. It's too open-ended. I'm sorry. Next question: how do you make sure fines are secured by assessment liens? It has to be language in your restrictions. So in your restrictions under the assessment provision, it'll say talking about the association's lien, and the association's lien consists of, and usually says, assessments, costs, interest, attorney's fees, and fines, if fines are secured. If fines are not secured, then that language will not be in there. That's typically where it is, but it may be in the fines section of the declaration where the fines are elaborated upon. And then usually there's a section that says the fines shall be secured and collectible in accordance with Article 5, Section 4.2 of the declaration, which is the assessment lien provision. So you got to really read through and see what your declaration says with regard to being secured by the assessment lien. What if the homeowner who complains to the association wants to remain anonymous in a neighbor-to-neighbor dispute? Well, that's a tough one. It's, again, if the owner wants to remain anonymous, the association, if it is a true neighbor-to-neighbor dispute, again, a barking dog that only this neighbor's complaining about, it's like, well, it's, if the association were to pursue that owner for the barking dog, let's go on a tangent here. Because I've been saying, unless there's multiple owners, you probably aren't going to want to get involved. Let's say it is a one-on-one, barking dog situation, and the association in this hypothetical actually pursues that owner for the barking dog, and then sends the demand letters, no resolution, files a lawsuit. Well, as a plaintiff in that lawsuit, the association has the burden of proof. If the only person complaining about this barking dog is this homeowner that wants to remain anonymous, more than likely that homeowner isn't going to want to testify or have a deposition or attend a hearing to provide, the testimony on the association's behalf to prosecute the case. So if an owner wants to remain anonymous, doesn't want to get involved, well, the association shouldn't get involved, because you're going to spend time, money, and effort on a lawsuit only to have the only witness you got unwilling to participate. So it doesn't make any sense. So if that's the case, I would tell that owner, hey, look, this is the reality of the situation. And now you guys will find this, and this happens quite a bit, where there's a violation, an owner complains to the association about a violation, and they are hot to trot. They will do whatever it takes Yes, they'll give a deposition, they'll go to trial, they'll go to hearings, whatever it takes. And then, well, we get center demand letters, file a lawsuit. And then we get to the point where, yeah, we do need that neighbor's testimony. And then they say, well, what do you mean I have to go take a deposition? What do you mean I have to take a day off and go to a trial? What do you mean? I'm not doing that. And the steam, the steam runs out. But when it comes to actually taking that neighbor something, it requires that neighbor to actually take action. Push comes to shove, or comes down to brass tacks. They often don't want to be involved. So I would caution you guys, when you do have an owner that's complaining, bring that up at the forefront, because there might be some say, well, I don't want to do that. Well, you're kind of done at that point. All right, next question. On-street parking is prohibited in the community, but extremely hard to enforce. Public streets, so we do not tow. Williamson County will not help enforce governing documents. Neighbors are telling on one another. No way to identify the owner of the vehicle. When letter is sent, the response is always the same, not my car. All right, there's not really a question in there, but I guess the question is, what can we do? And this, you bring up an interesting point, because, if it's a public street, arguably, could you put that? I don't know if you can put that back on the screen, Kyle, that question. Arguably, thank you. The public street is not technically under the jurisdiction of the declaration of the association. It is a public street owned by the city or the county and maintained by the city or the county. So there's an argument to be made that, well, the jurisdiction of the association and the declaration does not extend to property that the association does not own. Now, the contrary argument to that, or the converse of that, is that you could say, well, that may be true. However, in the declaration, it says you cannot park on public streets. And you signed, when you purchased your home, you basically entered into a quasi contract with the association to comply with the restrictive covenants in your declaration. So that's the argument. Those are the two combating arguments as far as public streets go and parking on public streets. I'm not aware of any binding case law, where that particular issue has been adjudicated. I am aware of one association that did pursue an owner for parking on public streets, and that did not go well for the association. It was not one of mine, so I'm not sure what the facts were. I just know that they did try to pursue an owner for parking on a public street in violation of the declaration, and the association did not prevail. But again, that was here in Harris County, not Williamson County. And again, all the facts are always different. But the point of me going into that hypothetical, or not hypothetical, that explanation is that it's a very difficult restriction to enforce, and it may be a situation where there really isn't a way to do it. But again, if this is a restrictive covenant, the neighbors that are complaining and they may know whose car it is. They could pursue that owner for the violation of the restrictions. Let them spend their time, money, and effort doing that. And as far as the owner of the vehicle, you could run a license plate, run the license plate to see who is the owner of the vehicle. That would definitely be a starting point as far as identifying the owner of the vehicle. All right, next question is a long question. I have a homeowner who reports their neighbor to me multiple times a day. I receive 15 to 20 emails from this homeowner each weekend, which contain videos of her neighbor when she is outside. The neighbor does have violations that we are already enforcing. However, the homeowner is constantly reporting issues to us that should be dealt with by law enforcement. The reporting homeowner calls her neighbor racial slurs, which can be heard in the videos she sends. What should the association do to make sure we are not liable for any escalated disputes between these two neighbors? There have been threats of shootings between the neighbors, and the basis for the homeowner's complaints appear to be race related. Additionally, would we be right to request a cease and desist against the homeowner making constant reports of the same issues to us? We have told her repeatedly to contact police for any criminal activity, and that we can only enforce what is in the restrictions. Well, you've pretty much hit the nail on the head right there, Rebecca, is that, it sounds like from what you wrote, most of what is being alleged is criminal or potentially criminal activity. If that's the case, that's a local law enforcement issue. That is not an association issue. The association is not the police. We do not uphold the laws. We uphold the restrictive covenants in our governing documents. So when you're dealing with issues like that, it definitely, recommend they contact local law enforcement. And as far as a cease and desist, that's something that I would contact your legal counsel on. Again, I don't know all the facts of the situation. I don't know what your restrictions say. It sounds like it may be to the level where a cease and desist may be necessary, but without having all the facts and without having seen your documents, I can't say yay or nay on that. If a declaration does not permit poultry on a lot, but the city allows it, can the association enforce a violation for the declaration? Yes, they can. Next question. What is the best way for an association to respond when someone accuses a home of having multiple families living at the property? That's a difficult question because it's very difficult to determine who is actually living at the property. In that case, usually if there are multiple families, there's multiple vehicles in the driveway or out in the street. That's where the license plate check would come in handy to see who's actually owners of the vehicle. But oftentimes the response is, oh, we're not living here, we're just visiting, or that kind of thing. That's again like the I forgot what the example was now, but that is a very the street parking. The multiple family violation residing at a property violation can be difficult to enforce. Again, get with your legal counsel as far as your options are with regard to that. We have a barking dog log that we require the reporting owner to complete over a period of time, then turn it into us before we will address it as a noise or nuisance complaint. It lists date, time, and duration, etc. It's not a bad idea. Where can we access the recording of this webinar? That will be after it's over. You can contact Kyle or Lindsay in our marketing department. You can get their information off our website, rmwbh.com. But it will be on the website. Now I'm saying that, but it usually takes a day or two to get uploaded, but it will be available on our website. Again, rmwbh.com. What time are we? 12:17. What happens if board members continually talk crap about a homeowner or former board member? Usually nothing good, honestly. I would advise the board member that, look, you're a representative of the association. It's not a good look for the association when somebody in a position of power for the association is, not being very complimentary of owners or former board members. It's just not a good look, and it could potentially rise to the level of slander. So the board member should really not get involved in that kind of issue, or in that kind of activity, rather. I have a homeowner who has a device that deters. Well, oh, there it is. I have a homeowner who has a device that deters animals with a frequency that is only detectable by animals. If the ACC approves the device because it is very discreet, but homeowners feel it is not appropriate or is wrong, is this a homeowner to homeowner issue, or can the HOA enforce its removal? If so, what is the basis of the removal? It is not harmful to animals, only intended to deter. Well, if the association already approved the device, if you're going to try and have the homeowner remove it, come back after the fact when they've already gotten approval for it, good luck with that lawsuit, Russell. Ain't going to happen, buddy. You go in front of a judge or jury and say, hey, judge or jury, we approve this, but we changed our mind. We don't like it anymore. We want to get rid of it. And judge or jury is going to laugh you out of the courtroom. So, if it's already been approved, the ship is pretty much sailed. I wouldn't pursue it. But again, the homeowners don't like it. They want to pursue it as some kind of a violation. So be it. But again, that's not going to, the owner that has the device should say, hey, I requested approval from the association. It was approved. And that the homeowners that are complaining are probably not going to prevail most likely in that situation. All right, last one. Austin PD is informing me that Austin PD is informing HOAs that it is up to the HOA to enforce parking in the streets per their CCRs. We dealt with it by the fining policy in place that specifically addressed parking in the streets. Should the HOA continue addressing it this way? Yeah, I mean, again, it is a violation. If it's a restrictive covenant that prohibits parking in the streets, and they are parking in the streets, it's a violation of the restrictions, and you can levy fines because of the as again subject to the giving proper notice for the property code or whatever, if you're a condo or a single family or townhome. So yeah, you can certainly continue doing it. Now, if the owner could potentially file suit against the association and alleging what I said earlier, that the street, it's a public street, and they don't, the jurisdiction of the declaration of the association doesn't extend to the street, but that'd be up to the owner to make that argument. So, but again, doing what you're doing, again, so long as it is a restriction, you can enforce it and via fines or demand letters or filing a lawsuit. I believe that is all the questions that we have. And so where are we? 12:20. I guess I'll shut it down here. I'd like again to thank everybody for joining me this morning. I hope you found this informative and helpful. Again, the recording will be up on the website. So in the next day or two, if you want to review what was said or somebody else wants to review it. I also want to remind everybody that our upcoming webinar is next Wednesday, the 17th at the same time. My fellow shareholder, Leah Burton, will be presenting on the latest on management certificates. So be sure that you guys register and watch that webinar. It's going to be very helpful and informative, especially because we have the December 1st date coming up, which is the date that we're going to start recording management certificates with Trek. So I think that's going to be a very helpful and useful webinar. So be sure that you check that one out. And again, my name is Eric. I'd like to thank you guys for taking the time to listen to me ramble on. I hope it was helpful, and you guys have a great one. We'll see you on the next one. Take care. Bye-bye.